This court has been unable to find any precedent supporting plaintiff's contention that inadequate police protection is a violation of any constitutional right. Welcome back, beautiful people. Public trust doctrine. Public trust doctrine and the liability of people who purport to be public officers towards you. So you want to hold people liable. You want to hold those who abrogate on your substantive right. You want to hold them liable, right? It sounds good to the ears and it feels good to the heart to have that conversation of holding people personally liable. Although the basics are very simple. But first, let's remove some presumptions. Because once these presumptions have been ruled out of the equation, it makes it easier to accept reality of things. Is it possible to be successful in holding people personally liable, privately liable? Yes, absolutely, it is. But let's first begin by washing the mind and brain of some generalized presumption. And we will begin with something called the public trust doctrine. This principle is what the majority of these tortfeasors utilize when it comes to mortgage, when it comes to public works of any city, borough, village, town, when it comes to any type of entity making a claim to being able to do something, or any type of employee making a claim to be able to do something or any power through an entity. Whether the employees know about this or not, they are nonetheless conditioned within the culture of that environment to act as though they have the power. And on the corresponding end with the public at large, where people go, you owe us something, you are a public servant. Most are not aware that part of why that thing, that phrase, public servant exists, is because of this thing called public trust doctrine. When one reads certain verbiage of certain parts of the rule of evidence and how certain evidence are admitted, when one reads certain general laws or public laws or session laws, whether on a state or federal level, it is inevitable. If you comprehend what this is, you will see exactly how it is incorporated and the way out as to how to hold them personally liable. People going on about your public servant, your public trustee. If one does not know about the public trust doctrine, one is merely functioning on presumptions. In order for you to hold someone liable, you must first prove and show that their actions is contrary to the independence of judgment of the public trust. And that verbiage, that quote, that phrase, the independence of judgment of public trust, is what you will see scattered in different res judicatas, where people attempt to hold employees personally liable to no avail. Know the reason why they always use this word public safety? If it's in the interest of the public safety, then we can barge into your house without a warrant. No, if it's in the interest of public safety. Do you know the reason why they say we can come and snatch your children and use the force of military powers that is abrogated by the state and federal constitution, where military powers shall be inferior to civil powers? At Illinois, it's in Article 2, subsection 15. On the federal level, it's within the 4th, 5th, and especially the 9th and 10th. Another reason why they can do all this ridiculous thing, usually when you read the res judicata or the excuse of affirmative defense that they will bring up, is, well, it's in the interest of the public. It's for public safety. When they pull that card against people, people will get upset because they hit a dead end. They know that whatever you're doing is really not assisting the public safety, but they cannot respond properly, but simply be upset because they don't comprehend why they can make that claim. And this public trust doctrine is also one of the ways why that thing called the 11th Amendment, which is the origin of sovereign immunity, it's the reason why it exists. Public trust doctrine, the qualified immunity or sovereign immunity, right here, 11th Amendment. Another video was done regarding this, where it basically explains how sovereign immunity has its origin in the 11th Amendment. The first 10 is the Bill of Rights. Is it not kind of interesting how the artificial one that they created right after the first 10 began with them not being able to be held liable? Quite interesting, isn't it? The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States, by citizens of another state, or by citizen or subject of any foreign state. What you just listened to, what you just read, is exactly what sovereign immunity stands for. And is exactly the origin of that thing they call sovereign immunity. But this very simple clause takes shape in many different ways when it comes to its operation. And one of the shape that it takes when it comes to its operation is this: public trust doctrine. Remember, we're speaking of holding them personally accountable, privately liable, so that you can really now begin to do a writ of attachments to whatever personal effect they hold. Or even if they think they put it in a trust, you can pierce that veil. That's the intent of subject matter here. But one will not be able to successfully and effectively do that if one does not comprehend this thing called the public trust doctrine. A lot of people are loosely familiar with qualified immunity, but they really actually don't know what it means. They loosely know that it's okay, well, they claim it so that they can dismiss your claim. If that's all one knows when it comes to sovereign immunity, qualified immunity, then the public at large really isn't ready to begin to make a claim that someone owes them something. Because the public at large themselves don't know how they relate to these people, or how these people relate to them, or otherwise. Public trust doctrine. Definition. The principle, then it's a form of maxim. It's put into operation. The principle that certain natural and cultural resources are preserved for public use, and that the government owns and must protect and maintain these resources for the public's use. The concept of sovereign immunity pretty much says we're not going to hold our own liable within our jurisdiction because of the incorporation doctrine, which is another doctrine, which is went over on Patreon in greater details. It also says that, well, since they're here dealing with natural resources for the benefit of the people, they can be given certain leeway. See, they're tying themselves to something very great, which is the natural and cultural resource. This is the foundational aspect of how any given nation runs. Without these two, being culture and the natural resources, no society will thrive. They have effectively attached themselves to the substance of what makes up society, and they are using that natural flow of life force to do ridiculous things. separate families, to steal from people, to trespass against people, basic secured rights. This is the reason why they are very comfortable, because they are attached to themselves to something that's thrice great. There's a maxim of law that says nature is thrice great. It's always mentioned here quite often that these people attach themselves to things that are bigger than the mundane aspect of what people see and get upset at. It is constantly reiterated here that these people are not stupid people. Is there some form of crookedness? Yeah. But are they stupid? No, they're not. They are utilizing nature's law and nature's God, which does not discern between good or bad, because only man discerns between good or bad based on our subjective perspective or understanding that's limited how things work. These tortfeasors comprehend that nature takes no side. So long as you function in accordance to its operation and maxims and principles, it would always favor you. And they are giving it to you word for word here. How many people know about the public trust doctrine, which is the foundation of the reason why these people do things comfortably and claim that buzzword, public safety, for the interest of the public, qualified immunity, sovereign immunity? This is it right here. The principle that certain natural and cultural resources are preserved for public use, meaning it's supposed to be for your benefit, and they are the benefactor. Benefactor is just another word for trustee, doing something for the benefit of someone else. And that the government, meaning any given entities, any given enclaves, any given municipality, city, state, and all the close corporations within it, own those natural and cultural resources. Listen to this. They're telling you that they own it. In the process of preserving it for you and everyone else, they own it, like a trust relationship. Remember, this is not isolated now. You really want to know how that Constitution is a trust document? This is it. You really want to know how they've taken that state and federal constitution and have subrogated it and flipped the position? It is through this thing called the public trust doctrine. Listen to the verbiage. The principle that certain natural and cultural resources are preserved for use, for public use. Meaning it's preserved for you, the everyday man and woman, your children, your grandmother, your grandfather, even that neighbor of yours that you don't like, that have that dog that constantly shits in front of your yard. It's preserved for everyone. But look at this. Look at the subrogation within the definition of it itself, which ties directly to sovereign immunity and qualified immunity. They give you and, meaning we've now added something else. That the government owns, meaning in the process of them preserving it for you, your benefit, based on the trust of what granted them power, which is Constitution. Which in American jurisprudence, constitutions are the foundational common law. Remember, at North America, American jurisprudence exists side by side with English jurisprudence. Those two things are distinct, but nonetheless, they intermingle and interrelate because of certain treaties by family, certain treaties by marriage, certain treaties by force of arms, certain treaties by commercial interests, and so on and so forth. And what you and I have just read and listened to right here is the first part, which deals strictly with American jurisprudence. This other part is a subrogated part that was brought as of recent time. To this first part, which is American jurisprudence, which is usually also loosely referred to as ancient jurisprudence. And English jurisprudence is usually referred to as modern jurisprudence. In the past also, another video was done briefly, or at least part of it was shown, that thing called Black's Law Dictionary that everyone uses. At the beginning of it, it shows you that there are two distinct types of jurisprudence. At the beginning of each Black's Law, it tells you that this book consists of two types of jurisprudence: American jurisprudence and English jurisprudence, one being ancient and one being modern. Look into it. Look into any given Black's Law Dictionary. Go to the first few pages. You will see it. It tells you. And for those with eyes to see and ears to hear, you will clearly see and clearly hear it. This is American jurisprudence here. And this is the English jurisprudence. The principle that certain natural and cultural resources are preserved for public use. You ever hear them loosely make some type of joke or banter about how Native Americans say the land does not belong to anyone and it belongs to everyone? That the land belongs to no one specifically and it belongs to everyone? The trees, the air, the water, the buffaloes, the badgers, they all belong to nature. No one owns nature. This is the same foundational principle you are reading here within this thing called public trust doctrine. Right here, this first phrase, this first part, the principle that certain natural and cultural resources are preserved for public use. Then there's an additive unto it, which is synonymous with this right here, the sovereign immunity clause, the establishment of the sovereign immunity within the 11th Amendment, whereby they now added the modern aspect of it based on colonization. We come here with force of arms, we establish our ground, we take the stuff, we own it, but we still try to keep faith based on certain things, because that's the foundation of how they're doing all this. If they kill their own foundation, they cease to exist. So they must always, at every time, proceed with the foundation, then subrogate the foundation. If you know what it is, you would always see it clearly. And the additive is this: and that the government, meaning the people that are acting now as a trustee based on constitutional principles in American jurisprudence and American common law, and that the government owns, there's something wrong with this, and must protect and maintain these resources for the public's use. This is where they slip in the change of hands right here of what it's supposed to be. If you're preserving it for the public, for someone else, and you're protecting and maintaining it for someone else, you don't own it. But remember, this is a trust relationship, whereby the trustee is a legal owner and the beneficiary is the equitable owner. And equity, being an extension and perfection of that law, would always supersede if you're willing to take it that far. How many of these people who are beneficiary of this public trust doctrine, who are being subjugated with military power, which is abrogated by American jurisprudence, okay, how many of them even know of public trust doctrine? How many of them know that this is one of the ways why they're taking your children, garnishing your checks, moving around your neighborhood comfortably, doing whatever it is they want to do, however it is they want? The doctrine's most frequent application is to bodies of water throughout the United States, meaning there are other applications, but the most consistent is water. Water is a commodity. You know, there are corporations and private entities and private peoples who actually have interest right in water. When you get any given land, if you don't find out that the lake behind it or the stream next to it has a right that comes with it, and if it's not within the language of that thing at the closing of you getting that house next to a lake, they can come and invoke public trust doctrine and take it. So if you have any house with any stream, any land with any stream, make sure you find out whether there's a water right attached to that. If it's not, then you should be modifying the language of that thing one way or another. The whole easement rights and the different, because there are different types of easements also, and we'll be going over that. But the different types of easement, all of that branch out of this thing, this very simple thing called public trust doctrine. If one comprehends public trust doctrine and the dynamics of it, as always, the dynamics is the key of how you can enforce any given thing. If one comprehends how it branches out and how it operates, its personality, which forms it takes, you will see everything clearly as to why it's happening the way it is. The doctrine most frequently application is bodies of waters, meaning there are other things, but most frequently the water is what it's mostly applied to. If water in any given landmass is depleted, there's no food. Shelter will be affected. In fact, the land, the robust nature of the crust of the earth where you stand on it, the only reason why certain areas are robust and hills and mountains exist is because of the water content. And that applies to aquifers, which are underwater resources, pure. If any given land was to be depleted of water, it can decrease the thickness of the land by 50 to 100%. Have you ever been around your childhood neighborhood and you feel something is a little bit different? You feel the landmass looks and feels a bit different. It's quite a little bit the same, but still different. It's because the water content underneath the ground and the soil changes. Water is life, and whoever controls it, in this case by way of public trust doctrine, holds a lot of power, because everything else is a comfort upon it. Doctrine's most frequent application is to bodies of water. This bodies of water is not the obvious stuff that you see like oceans, lake, lagoons, all that. Way more. Throughout the United States, most lakes and streams are maintained under the public trust doctrine, which is what we just went over. If you get any land with lakes, streams on it, better find out if it has water rights attached to it, because if it doesn't, this will kick it. And it comes in many different forms, easements, etc., and different types of easements, typically for the purpose of drinking and recreational activities. Generally, the public trust doctrine also prevents individual properties from extending to the ocean. See, it will screw people over by subrogation. If this was supposed to be a doctrine that actually causes them to maintain, to protect, to preserve public use, why are they using it as a means to prevent you from doing something? That should raise a red flag. But if one is not aware of this, how can they ever do anything? They are playing the role of a sovereign. I hope people realize that this is what a sovereign does. Rules over the water, rules over the land. This is the doctrine that they are operating from. This thing called public trust doctrine is just a blanket. If you were to take the blanket off, it would just basically say sovereign immunity. Oh wait, they do claim sovereign immunity. You see now, that word sovereign immunity, that sovereign within that phrase actually means something, because of the public trust doctrine. So you want to sue someone personally now, right? Better know what public trust doctrine is and how it applies to them, you, and how you can strip them of its protection. Extremely important. The mind is the cause. The outer existence is the effect. If the people's state of mind is dull, then the outer reflection of everything will be an effect of that dull state of mind of people. And if the parents and the grandparents are dull, how do you expect the children to live a better life? The most your children will be doing is just complaining and being angry, but without basic substantive knowledge of why and how their anger actually makes sense, and why and how that anger could be used as proper fuel, married with proper knowledge and wisdom to actually begin to do something beyond just getting mad. Getting upset only causes them to milk this even more and says, well, according to public safety or for the public interest, we're going to now stop you from being able to exercise basic rights to redress and grievance, to gather, to speak. We're going to isolate certain venues so that you can only exercise freedom of speech in certain places. People aren't even aware that this thing called freedom of speech can only be exercised in certain places because they've isolated this so much based on this thing called public trust doctrine. It is going on right under everyone's nose and no one is talking about it. All these people yelling, harking, and barking about rights, saying they're bad, they're evil, they don't have the power to do this, that, or people claiming that they themselves are the sovereign. You don't know this, and you're saying you're sovereign, and you're pointing fingers that they're bad. Your mind is the cause. Outer reflection of everything else is the mere effect of that cause. And a competent mind is a world of demise and a world of pain and suffering. So now one wants to hold them liable. Once you've put into consideration this thing called public trust doctrine and you start to ponder how you can actually put it to use and the importance of trust. Remember, public trust doctrine. And how you becoming in through trust and its own language and invoking the private right within that thing called the Bill of Rights. So homogenize the language of your law as a treaty with it so that you can pierce this trash that they have going on. Believe it or not, the solution has just been given to you. Once you've put that into consideration when it comes to trust matters, now transition to contract. The contract is as simple as this. Since they are supposedly acting as a trustee for your benefit, but they subrogated you because, well, they figured you don't know much about it. The question now is, are they obligated to protect you? They speak of the natural resource here and how they tie themselves to it to become the sovereign of the land, air, and water. And everyone else is just considered a peasant to them. Now the question is, are they obligated to protect you? Because they're supposed to be protecting and maintaining and preserving the natural resource. But what about you, the one who's supposed to be the beneficiary? For instance, there are military extensions called the police departments. Are they obligated to protect you? Forget my own irrelevant words. Listen to them tell you. SAP versus City of Tallahassee. The Second Amendment amended complaint alleged that the officer owed appellant a special duty to protect her from physical assaults and were negligent in failing. And by the way, the negligence she's claiming in this case, she did not prove the elements test or standard, by the way. Just as another important side note, which is another subtleties they look at to see if you're competent, if you have the right cause of action, which is your mind and your competence. The Second Amendment complaint alleged that the officers owed the appellant a special duty to protect her from physical assault and were negligent in failing to properly investigate the behavior of the men. And count two, appellee Adam, Richard, Kendrick, and Kathleen Jones were alleged to be franchisees or licensees of the hotel and jointly and severally liable with appellee Holiday Inn, meaning since they are employees of this entity Holiday Inn, they're now being joined personally under presumption of severe liability, which we went over with corporate veil and whatnot on Patreon. And the one appealing the situation, which was ruled to her favor, is also saying, well, the cops should have protected her then. also in the process of whatever happened. For the negligence of the hotel's management in failing to provide adequate security in the rear parking areas, the trial court dismissed both the City of Tallahassee and the Holiday Inns Incorporated since no showing of duty to Miss Sapp was made. The hotel owners did not owe her any duty to protect her, and the municipal officer did not owe her any duty. Why? Let's go further. Remember, public trust doctrine says they're to protect, preserve, and maintain natural and cultural resource. You see now why people with culture from other parts of the world get treated differently? A lot of people think it's, they don't like us, they're racist, they think they're better than us. Ask yourself, do you have a culture? Look, be honest with yourself. Be truthful to yourself. But nonetheless, the city's liability, it is clear before a municipality. It is clear, meaning it's undisputable. It is clear before a municipality may be held liable for the negligence of its employees, there must be shown the existence of a special duty, something more than the duty owed to the public generally. And the duty owed to the public generally are these: the preservation, the maintenance, and the protection of natural and cultural resource. It's that simple. If you're trying to say that you, the everyday man, which they would, for the sake of abating liability, they would deem you a private man, but for the sake of joining you, they would join you as though you're an employee of their municipality. They can invoke it at any given point. But do you know the difference and why and how they can do that? Part of it is also in the rights and obligation of contracts. So now the question is, are they liable to protect you? Are they bound to protect you? They're saying no, they're not. Unless you can prove that there's a special duty for them to do so, meaning you have to hire them and compensate them as your security guard. Because they're simply in business to cut to the chase. Try this. I dare you to. Go whenever you see any type of security guard or any municipal police anywhere. Look at what their demeanor towards you is. And afterwards, approach them as though you want to hire them for some type of private party that you have going on somewhere. And see how they quickly change. Seriously. It's almost like magic. You know how people ask them for their business cards when shit hits the fan and they kind of hesitate or play dumb? Or they give it to you like they're confident and they're not afraid, but in truth they're kind of wondering what you want to do with it? Act like you want to do business with them or hire them or contract with them. Start speaking that language of commerce to them and see how quick they whip out that business card. Experiment with these things. Seriously. Ms. Sapp contends the police undertook a special duty to those persons using the rear area of the Holiday Inn. Yeah, because the Holiday Inn contract with the local municipal police and compensates them so that their business could be protected. It's all business. And Miss Sapp is not getting that message. She thinks they owe her something. See why you have to get your affairs in order? And if most of them don't consciously know it, the culture within that working environment conditions them to behave accordingly. Because you will find most municipal police, 8 out of 10 of them are incompetent. Most of them got some childhood mental issues that they try to prove a point to themselves by joining these organizations, by joining this body politics to exercise some type of power that they lacked as a child. The last thing you want to do is suffer from that same syndrome. Always wanted to yell and hark and bark at something just so you could feel powerful temporarily. That is not where your power is. Your power lies in competence. Nonetheless, Ms. Sapp contends the police undertook a special duty to those persons using the rare area of the Holiday Inn, and she properly comes within that class, so she presumes. Such allegations are not sufficient under Florida decisional law. That privilege that she observed those municipal police afford to the people who go to a Holiday Inn is for the protection of the business itself and the employees of that business. And in fact, they are trained to look at everyone else who is a customer as a potential belligerent to that business. That's why you get the feeling you get when you're around these municipal police, because they're trained to preserve the integrity of monetary interests of businesses. It's really that simple. Whatever people perceive, because they've been conditioned since childhood to love cops, because the cops came to their grade school and they put up a show, because of course the cops in that municipality is contracting with the school to do that and condition people through direct hypnosis since young age. And then they ask you, what do you want to be when you grow up? Oh, I want to be a police officer. I want to be a fireman. All that trash doesn't mean these people owe you anything. And they're telling it to you in black and white on an appeal level case. So before you say they're corrupt, they're fraud, they're bad, first comprehend the foundational principle as to what they are there to do in the first instance. And then comprehend how you correlate with them and how you can really make them liable. That's what you should be thinking about throughout this whole thing. But then it brings you back in a full circle. How can you hold them liable if you don't know the limits and confines of what they're meant to do in the first instance? Protect the natural resource and cultural resource. So are you seeing the language of how you to construe your trust? How you must tie it to some form of culture one way or the other? These things are not being introduced just for the heck of saying it. Think multifaceted now with everything else that's been spoken of in the past. None of these are isolated. And believe it or not, these are some of the attributes that will be observed when you come in through your trust. This court in Florida, First National Bank, Silver, held the plaintiff, guardian of 2 minor children, stated a cause of action for the negligence of police officer in failing to investigate and report a complaint of child abuse involving the father and the minor children. We held, quote, here the municipality, through its employees, corporate veil, engaged in an undertaking with reference to the Daubert children. Other persons, all of whom were in positions to have gone to the aid of the Daubert children, but for their reliance upon the municipal employees refrained from rendering aid. Many some children were in some deep trouble that was quite obvious and witnessed by others. But people put their trust, their public trust, in these municipal employees that, oh, you know what, that's what they're here to protect us now. Now, how many people call 911 emergency because they think they're gonna save them, and it turns out to be the complete opposite? You know the reason why they can show up and you, the one who called them, you get arrested and assaulted, and then they sue you in court after that and dump you with an undue burden of litigating and mitigating and losing time over something you did not do, but you're the one who was the victim who called them. You know the reason why they can just flip that? It's because they don't owe you anything. And the same circumstance occurred here, where the lives of innocent children were at play, and people could have done something, yet they saw their superheroes and said, you know what, they got it. It's in their hands now. People have no more balls these days. People don't know how to handle their affairs. And they milk that to the best of their ability. They will milk it. They tell you, stand back, we're doing this, doing that. But really, they're just functioning in their private capacity to protect private interests. What about your private constitutional interests? Which is another standard when it comes to what they're doing. They're supposed to weigh something called countervailing governmental interest with constitutionally secured right. That's the verbiage. They don't weigh the countervailing governmental interest, meaning commercial interest, of any given establishment to protect their properties and monies. They don't weigh that with your constitution secured right. So now they come into any given area that has nothing to do with commercial interest, and they're giving you orders, when in truth they're not even there to protect you. So what are they there for? And most importantly, what are you doing? Do you know your rights? So their superheroes in Cape came and they just left it to their hands. And they're making reference to this specific instance to show that these cops owe no one any obligation. Remember, these women are saying, well, I noticed them give some type of privilege to the Holiday Inn employers, and the entrance in the back, she's thinking it's to protect the people going in. No, it's to protect the business itself. And the court is saying such allegations are not sufficient on the Florida decision on law. Remember, this is on an appeal level. And then they gave an example of previous experiences where people held the same presumption, where lives of children were at stake. In the Supreme Court's denial of certiorari, City of Jacksonville versus Florida First National Bank of Jacksonville, Justice England, in a concurrent opinion, expanded on this key point. As the district court's careful opinion shows, however, the facts in this case are so disparate from any other case which has ever considered the scope of a municipal liability that the requisite factual similarity is wholly absent. Look at that. How much more clear can that get? Merely to mention some of the controlling facts here, in brackets, as alleged in the complaint, is to highlight the difference. In this case, a state statute directed procedures for the detection of and prevention of child abuse. The Jacksonville police failed or refused to comply with them. Meaning now if you're dealing with any state session laws, any state general laws, any state public acts that's been statutized that deals with the protection of people, the protection of persons, papers, in effect, harmonious with the state or federal constitution, and it's written down as part of the governing laws of any given state. They're insinuating here by letting you know the police departments are not obligated to follow that, because their obligation is not to protect you. Listen to this. In this case, a state statute directed procedures for the detection and prevention of child abuse. The Jacksonville police failed or refused to comply with them, with the consequence that the appropriate state agency never had the opportunity to know that the Daubert children were in need of its services. No similar procedural default resulted in injuries to the very persons the statute was designated to protect. Meaning, if they don't protect or prevent child abuse, so long as it doesn't fall under their scope of services to businesses that they're obligated to, then they're not at default of any type of liability, and you cannot hold them personally liable because they're under the corporate veil of municipal activities. No similar procedural default resulted in injuries to the very persons the statute was designated to protect occurred in the decision cited from conflict jurisdiction. We are slapping this woman, Miss Sapp, with examples after examples after examples that, look, these municipal police do not owe you any form of protection. So now when you want to sue them personally, and you're saying one of the reasons why you're suing them is because they owe you some form of protection, you might as well just throw that out the window, just give it to the birds to eat, and focus on something more substantive. If you're invoking your security of person's right, in fact, and you're attaching it to their need to protect you, something is automatically wrong right off the bat. Just as many people make the presumption that, well, you can't copyright your name, you can't do this to your name, you can't trademark your name. That's a problem, because you're thinking that is your name in the first place. That is an issue that you need to wash off your head in the first instant. The video was done regarding character evidence and to prove the character of any given defendant. If you don't properly delineate the character of that individual from you, and you're thinking it's still you, it's your name, you're saying because of that you cannot invoke asset and property protection methods, you're no different than people that's coming in and exercising some supposed right because some cop owes them some form of protection. The mind is the cause. The outer reality is just the effect of what the mind is. Your mind is the competence. And if your mind is not competent, you will not have a cause of action. The equation and algorithm of these things are very, very simple. People complicate it for whatever reason. It's like people have been conditioned to just do one thing and one thing only, to complicate the most simple and basic things. They then slapped her with another res judicata, Wong versus City of Miami. Miami police were held not to owe a special duty to merchants who had requested protection during the 1968 Republican Convention, nor could police officials' deployment of forces be considered prima facie negligence. Whoever compensates them to provide protection is who they work for. It's that simple. Municipalities are a corporation, aka home rule units, aka body politic, aka private entities. And their private force of arms cannot be compelled to provide service to people who are not putting monies in their pocket, who do not have contract with them. But guess what though? So this is why, and this is how, when people say all crimes are commercial, it's all commerce. This is the reason why. Beyond just reading the verbiage of some CFR, posting it on social media and then passing it on and then following the hype train, you better know the dynamics of it. Because this is the reason why people are suffering. That CFR, what you're going to state it on a piece of paper in court, and it's not even going to be admissible because it's not law. You need to go to the root of the public law. Competence is the cause of everything. Once you're aware of the reality, you're able to access it. There is no showing of violation of statutory procedures by the Tallahassee police. She's not even invoking the Constitution or their oath of office. That oath of office is what ties them. This thing right here. See, this thing is a double-edged sword. They subrogated to create sovereign immunity. But you can put it in its right place by bringing it back home. You know who and what they are. They can have private entities all they want, but the Constitution is the founding principles that they are bound by. But if one does not even know how the Constitution functions, how then can you ever be able to put it to use or even comprehend or make sense of these basic doctrines that branch out of it? When I speak of the Constitution, I'm speaking specific to the Bill of Rights. There is here no showing of a violation of statutory procedures by the Tallahassee police, nor is shown of a direct and personal contact with Miss Sapp. There is no personal contract with her. There is no allegation in the complaint of reliance by Miss Sapp on the city's police surveillance at the time the incident took place. This is not a situation police authorities undertook a responsibility to a particular member of the public, exposing them without adequate protection to risk, which then materializes into actual injury. All this legalese crap is basically saying they don't have private contract with her on a commercial level, and so they're not bound to protect her. In other words, she's not even invoking any form of constitutional rights, constitutional basic rights, and bringing their oath of office into it. What she should have done is bring in their oath of office and then remove the whole presumption that they're there to protect her and go from the angle of public trust. And then, if possible, bring other claims in, like all the other stuff we've been speaking about on this channel. So that's about, what, 3 or 4 case laws? It's basically letting you know that in the process of you attempting to hold them liable, just be well aware that they don't owe you any form of protection. So isolate within your claim of liability on their part that part of their liability would be a lack of protection. Throw that out the window because they don't owe you any form of protection. If it's not clear enough through the actual act of how they deal with people, here's res judicata telling you. Here's another res judicata. Rafe versus City of Philadelphia, U.S. District Court of Eastern District of Pennsylvania. Memorandum in order. This is an action brought on behalf of minor plaintiff against the City of Philadelphia, seeking damages for an alleged violation of plaintiff's constitutional rights. All right. Saying something, right? Constitutional rights, quote, right? Plaintiff claims that the city is the issue here, automatically the city. You're suing a fictitious entity for what you call your constitutional rights. And then on top of that, to add assault to injury, violated her 14th Amendment right. She's claiming 14th Amendment. So that means she doesn't even know what a Bill of Rights is. Meaning she doesn't even know she has a right. She doesn't even know this thing is just something somewhere in the air flying out there. If you read the verbiage and the intent of that thing called 42 U.S.C., which most people will invoke, which this woman is also invoking. If you read the language of the public law at the beginning, they will tell you it was created for 14th Amendment, or it had its origin based on 14th Amendment. The 14th Amendment was what gave rise to this thing called 42 U.S.C. 1983. And if the 14th Amendment was not even properly ratified, and it's not even part of the original intent that affords you private right of action, do you see the compound and overlaying lack of ability to enforce or hold anyone liable that's automatically existing right here within the first paragraph? Plaintiff claims the city violated her 14th Amendment right by failing to provide her with adequate police protection. There we go again. She also alleges a pendent state law tort claim against the city. The defendant, City of Philadelphia, meaning some lawyer, because lawyers can only represent fictitious entities. And there are many stare decisis on that. Lawyers exist to simply represent fictitious entities. But on record, they just put as City of Philadelphia. But when they sue you, say on a state level, they will put the people of so-and-so state versus you. In that case, on that level, they're bringing the power of the people against you. They're bringing the constitutional power of the people against you. Look at any court case against you. It would always be the people of so-and-so versus you, which is another reason why you must also do constitutional challenge, because they're bringing the power of the people and state based on the state's constitution against you, despite their corporation doctrine. But that's just another digression. The defendant, City of Philadelphia, has moved for summary judgment pursuant to Federal Rules of Civil Procedure 56. The city bases its motion solely on the pleadings. Neither party have filed an affidavit, and apparently no deposition have been taken. To go down. Since our earlier decision, the Supreme Court has ruled that city, quote, city is a person within the meaning of 1983. Listen to this. 42 U.S.C. 1983, right? Civil rights. Okay. Regardless of what year you use, regardless of whether you use the older version or the new version, listen to this. Since our earlier decision, the Supreme Court has ruled that a city is a person within the meaning of 1983. and can be sued under that section when the unconstitutional action alleged implements or executes a city policy or custom. That's it right there. They're telling you the only contingency of how a city, a fictitious entity, can be sued under 1983 is if you tie it to their violation of their policy or custom and in their private law. Man, now it has absolutely nothing to do with your rights. It's all based on them now. Do you see the frame of how things are being switched automatically? One will read this and completely omit or fail to see that. Now the foreground principle is not even your basic rights preserved within the Constitution, because one, you're coming through 14th Amendment. It's presumed to benefit them. So now they would look at things from their perspective, and they will set the pace based on their policy and their customs. And then the good old Monell Doctrine. This action is therefore being considered as one brought under 1983. Particularly since the complaint alleges that the city pursued a policy of providing inadequate police protection by refusing to respond to calls based upon mere suspicion of a crime and failing to provide adequate protection in a high crime area. You do know they're telling on themselves, right? If anyone under any given circumstance has been treated in a torturous manner, in an unconstitutional manner, and they're claiming, well, we're trying to protect the people. They're giving you every tool to show them that, look, no, you're not. Your job is not to protect the people. That's an affirmative defense for you that you can use at any given point. But moving on, the question presented, therefore, is whether the plaintiff has stated a claim upon which relief can be granted. By alleging that the city's policy, now you're limiting your whole substantive right. All the possible things you could claim, now you just limited it to their policy, which was carefully and intelligently constructed by attorneys to always favor them. Now you're saying you're an employee of that city, because for you to be invoking the city policies as the foundational base of some right, that means you must belong to their body politic, and the only way you can belong to them is to be an employee, aka a slave of that entity. Do you see all the flaws that already exist within this, from the beginning to the middle point, and it carries just like this all the way to the end? They're telling this woman that your case is a failure without really blatantly. See, all this right here could simply be summarized in one very simple explanation, which is your case is a failure. But they'll throw all these legalese as a cloud just to create more confusion. The amended complaint alleges that on February 5th, 1973, the minor plaintiff, while a business visitor in a shop known as Peasant Garb, to give the address to solidify the residency status as a subject, was shot and wounded by one Kenneth Taylor, aka Kenneth Davis, who, in the company of and in conspiracy with one Angela Frierson and one William Jones, was then robbing individuals in the shop at gunshot. Those in the hood. As a result of a gunshot wound inflicted by Taylor, the minor plaintiff is paralyzed from the chest down and is permanently confined to a wheelchair, meaning somebody was actually seriously injured by another man and woman. And they're saying, well, you failed to protect us. The court is slapping them back saying, no, you got this twisted. They don't owe you any obligation to protect you. Besides, since you're coming in based on 14th Amendment, we might as well base your whole right on their criteria of their business affairs, their standard procedures, their customs and culture. And guess what all that says about you? It says you're not part of them. But they can invoke the public trust doctrine though, as they wish, because you don't know your rights anyway. This is the demeanor, the underground demeanor that these people are dealing with her with. Plaintiff alleges that the city is liable in damages to her on the basis of her allegation that the city failed to provide adequate police protection. She bases her claim of inadequate police protection on the allegation that the police department has a policy of not responding to calls for assistance unless and until a crime has actually been committed, and on the alleged failure to provide adequate police protection in a high crime area. Plaintiff contends that the conduct of the defendant, City of Philadelphia, denies to her the right to equal protection of the law, in violation of first section of the 14th Amendment. It goes on with that trash. And look at what they're doing here. They're putting it in quotes. Deprived her of rights, privileges, and immunity guaranteed by the constitutional law of the United States. Deprive her of her, quote, rights. Look at this. To a reasonable, safe place in which to live and carry on the ordinary pursuit of life. Deprive her of her, quote, rights to lead a normal and healthy life, and deprive her of her, quote, rights. In other words, they're saying this is just an imagination of yours. You don't have it. To reasonable and adequate protection from criminal assault. Construing the amended complaint, meaning we're now going to bring constructive trust, because the way you've came, what you're doing, everything you're saying, what you think is going on is dead. So we're just going to construct it. Construing the amended complaint in light of most favorable to the plaintiff. We're not going to play the role of the good guy. We're going to be your God. We're going to, play the good guy but at the end say no. It basically alleges that the police protection afforded her was inadequate. This court has been unable to find any precedent supporting plaintiff's contention that inadequate police protection is a violation of constitutional right. If this is not succinct and clear enough compared to the first 3 or 4 case laws shown, I don't know what else to say at this point. Look at this. Wright versus City of Philadelphia. This court has been unable to find any precedent supporting plaintiff's contention that inadequate police protection is a violation of any constitutional rights. And everything else after that is in harmony with that same perspective. They owe you no obligation to protect you, your children, the pursuit for life, liberty, happiness, security of persons, papers, effect. You do though. You owe yourself that. The best way to do that is to be competent, to separate that power and jurisdiction, and know how to hold them liable if they trespass. This is more evidence letting you know that they're functioning privately. The moment they trespass, this is the evidence that's letting you know most of the things they do to people, they can't do it. But people speaking about qualified immunity, they're bad, they're fraud, do they know about this? Put all those basics into consideration. And there are way more case laws after case laws after case laws. This is the reason why you can call them and they would arrive 40 minutes, an hour late. This is the reason why you can call them and they will end up arresting you, the one who called them. They are their own home rule unit. What people ought to be looking into is pulling up their charters. And within every charter, it will tell you where they got the power to create that charter, which is the state constitution. Apply that foundational principle of that home rule unit with the individual oath of office taken by that man or woman, and then invoke any part of the Bill of Rights, and start to think to yourself, how can I pierce this corporate veil? What have they done that abrogates it? Be realistic with yourself. This is the reason why you sue them personally, and in their supposed capacity as an employee of that home rule unit. Literally, them personally, John Doe as a natural man being sued, John Doe as an employee of so-and-so home rule units are going to be two different defendants, because those are two different entities, two different capacities that will be served at two different locations. One in their personal place of abode, other in their place of work. Put that into consideration. Until next time, take care and best of luck. Hey, I'm inviting you to join my Patreon if you haven't already. Over there, we speak about things that we don't speak of on YouTube. We speak about trust-related matters and other subtle details regarding property and asset protection. We speak about financial related matters and a lot of things that people seek and can't quite put their hands on or get a better understanding of. We speak about child support, privacy, things of spiritual nature, subtle arts of suing and whatnot, discharge, and much more. Take a look at it. Take care. Best of luck.